You're live. Okay, good morning. We are in Senate Judiciary, March 24th. We are taking up page 626, and we have Charlie from the Vermont Network and the Florida Lookers.
Sure. Well, thank you for having me. Charlie Listerman. I'm the policy director at the Vermont Network Against Domestic and Sexual Violence. I am grateful for the opportunity to speak in strong support of H626. And I'm also very grateful to members of this committee and the chair for introducing the companion bill to this in the Senate S256. Image-based abuse includes the creation, distribution, and threat to share explicit images of a person without their consent. And this bill covers three different kinds of image-based abuse. Video voyeurism, where images or recordings are taken without a person's knowledge or consent in a private setting, such as a hidden camera in a restroom. Non-consensual disclosure of explicit images, which are images that could may or may not have been originally obtained with permission and then are later shared without permission. And Vermont statute on non-consensual disclosure of explicit images, also called revenge porn, includes digitally altered or AI-generated explicit images. And lastly, sextortion, which is a form of sexual exploitation in which a perpetrator threatens to disclose a real or synthetic explicit image unless the victim complies with commands. This can occur in the context of domestic violence. It can also occur in the context of trafficking or online scams. We really see this bill as an opportunity to evolve as technology evolves. As technology advances, this harm has become much more common and much more severe. And our law should be updated to protect Vermonters in this new reality. When an image is shared online, it can spread instantly and be nearly impossible to remove. The survivors face a chronic sense of threat that their abuse will continue no matter what they do because an image will remain accessible online. And those consequences are wide-ranging. It can impact a survivor's safety, reputation, relationships, job prospects, and health. And it disproportionately affects young people and will shape the rest of their lives. One piece of research on this issue that I think is really important is that research shows victims of image-based abuse experience significantly higher rates of depression and PTSD than even victims of other forms of domestic and sexual violence alone. I think that speaks to the chronic level of threat and harm that comes from image-based abuse. So this bill addresses image-based abuse both in civil and criminal law, and I'll speak to the civil law components first. H626 strengthens remedies in civil court for victims of video voyeurism and non-consensual disclosure of explicit images. Survivors can file a lawsuit against a perpetrator for the harm that they have caused. And those provisions retroactively apply to acts of voyeurism and non-consensual disclosure of explicit images committed before those acts became crimes. Or excuse me, after those acts became crimes. It also clarifies that the diagnosis of a trauma-related disorder, such as PTSD, meets the requirement of actual injury in a civil claim. I know Michelle Tiles, Legislative Counsel, spoken for walkthrough about the Kilburn v. Simmons case and how Justice Reiber, Chief Justice Reiber, and Justice Wakeles noted that in their concurring majority opinion. That our laws have not really had pace with our understanding of PTSD and psychological trauma, and that this area of court law should be developed more by the legislature, and we couldn't agree more. On the criminal front, H626 shifts the statute of limitations for image-based abuse crimes to align with how they actually unfold. Current law gives victims 3 years from the time the crime was committed, but many victims don't discover an explicit image of themselves online until years later, sometimes after it's already been viewed by millions of people. And under current law, their opportunity to pursue criminal charges may have expired before they even know they were harmed. And so this still extends the statute of limitations for voyeurism involving images, voyeurism involving disclosure of images or recordings, non-consensual disclosure of explicit images, and sextortion to 40 years. And this will ensure that survivors have a meaningful path to justice.
Brother, did you say 4 years?
40.
Would it just make more sense to have the statute of limitations be upon discovering the offense?
That was in the bill as introduced. And, Michelle Child, I think, spoke really well to this. I'm sure Kim can as well. Because the House committee weighed out whether there should be a long statute of limitations or whether the clock should start upon discovery. It's my understanding that there aren't other criminal statute of limitations in Vermont law that have that kind of structure starting at discovery. Then in the case, there will be discussion and debate about when that date of discovery was. And it was thought that it would be, more protective and straightforward to have a long statute of limitations.
Thank you.
You're welcome. Lastly, H626 creates penalties for criminal threatening involving explicit images or sexual conduct. Threatening to disclose an explicit image is a deeply coercive act. It can be used to compel victims to provide money or labor or to engage in sexual activity against their will. It's an element of coercive control and domestic violence, sexual violence, and stalking, and we feel it should be recognized in Vermont criminal statutes. I will also note that we are working closely with a survivor on this bill who's been deeply impacted by image-based abuse, and we would just hope that the committee would have an opportunity to hear from her directly in the coming weeks. I thank you again for your time and consideration, and I would be happy to answer any questions.
Thank you. I guess quickly, could you send the contact information of the person who'd like to testify to Emory, and we'll get that sorted out for some point in the near future.
Okay, perfect. Thank you.
Maybe any other questions for Charlie? Thank you, Charlie.
Thank you.
Okay. Yeah.
Good morning. For the record, Kim McManus, the Department of State Attorney and Sheriffs, here before you on H626. The Department of State Attorney and Sheriffs supports H626. As Ms. Glisserman was just testifying to, this bill is seeking to keep pace with technology and trying to keep pace with newer ways that folks are harming others by disclosing these images. And as the Van Buren case said, the disclosure of these images creates a digital stain almost impossible to fully erase. The harms that these crimes cause, again, as Ms. Glisserman just stated, cannot be underrepresented. It's a crime that for many, it moves on and on because it's so difficult once the image has been disclosed to get that image back. The restructuring voyeurism, which is section 1 of the bill, as presented by legislative council, it's all pretty much the same. There's a little bit of rewording, but it's mostly just reorganizing to distinguish between the act of viewing someone who has an expectation of privacy versus filming, photographing, or recording. And just with that, also pulling out that then disclosing an image after you've taken it voyeuristically has a higher penalty than the recording and or just viewing, if that makes sense. So there's in voyeurism, there's the viewing, there's the photography, filming, recording, and then there is a disclosure there with the voyeurism statute. So that's just something to note. And that is a higher penalty of, again, because of felony of up to 5 years. Section 2, again, is mostly just cleaning up the disclosure of a sexually explicit image. We have no issues around the work that has been done there. And then section 3 is creating a new crime for sexual extortion. It's important to distinguish disclosure of a sexual explicit image without consent. One of the reasons somebody might disclose that is to intimidate, harass, or threaten a person. But sexual extortion, it's an active threat that you're threatening to expose the image, or you're compelling someone to do certain behavior, or you will release the image. So there's extra elements that the state would need to prove in order to see that forward. And the sexual extortion statute, again, has higher penalties than simply the disclosure under the 2606, what we sort of locally call the revenge porn statute in the past.
And I do have a few, I think, two questions to this. I'm on page 11. I'm planning to have the AG's office and to talk about this too, but maybe you can clarify it. Line 5, the definition of an identifiable person. Can you expand a bit more on what that means? Yeah, can you just expand a bit more?
Sure, and absolutely, Attorney Padula also will be able to give you wonderful testimony on this. But essentially, when we bring these cases forward, we need to connect that the image is an identifiable person in that if I took the picture of the back of Senator Matos, and I'll keep you fully put for the purposes of this meeting. And so it's the back of Senator Matos, he's walking away. There's a question of whether I can identify him as Senator Matos, right? So I can't see his face, but maybe he has identifiable hair, or he's wearing, oh, that suit jacket. Like, I know that I can connect that to Senator Matos, and I would bring another piece of identity, evidence to connect those dots. So when we have these explicit images, sometimes the face is not in the image. And so then the question is, like, is that body identifiable to a person? I had a case of disclosure of explicit images, and my victim had a very recognizable tattoo on her body. And it was something that people who knew her would recognize that tattoo. So when there was an image of her body without her face, we didn't need her face to identify her, nor people who knew her tattoo. They'd be like, oh, that's so-and-so. That's a picture of her explicit body. So that's how we connect identifiable.
And
That makes sense.
it does. And so I guess a follow-up to that, and maybe it's too hypothetical, but I'm wondering about being able to identify the background of the room that somebody's in. Like, let's say you can't identify the person, maybe their face is blurred out or something, but would you still be able to use this if you're able to identify, like, oh, that's so-and-so's room? And do you get what I'm saying?
I do, and it will depend on the facts and circumstances. So if yes, if it's a person on the bed in the room, and then the person saying, well, that's my room, and I'm the only one who would be in there. And so we're trying to make that connection. Could there be an argument against it? Possibly. So that might be something that we're arguing over. College housing and different people are using different rooms. We start to get into maybe that is more complicated, but that's where, oh, the face is blurred out, but oh, that bracelet. If someone says bracelet, like then we're able to. It'll depend on that information, but we have to connect that. If we don't have a direct image of the face.
Thank you. Yeah, Senator Thompson.
I do. So I appreciate you clarifying that intent to do harm piece is in the sort of extortion, like that exploitation piece. What I'm wondering, and maybe you can answer this, is as I'm looking through, sort of circling back to the voyeurism, and I appreciate it being restructured to be more clear and modernized, but in the disclosure of the videos or images to a third party, it only covers what's previously in the bill, which is that they were not collected with consent. And I'm wondering if in the underlying law, or as you see it anywhere in here, we are also addressing someone sharing things that might have been collected with consent, but there was no consent.
And that would be covered under 2606.
Okay, so it's an existing law. Okay.
Yeah, so and it's really interesting. So
Voyeurism is structured. If you disclose it, you are the one who took that image, without any consent. It's because you're set up with your camera across the street. You've done two things there that we would have to prove. Versus, right, where have your two partners share photos with consent with each other, but then one discloses it without consent. That would be under 2606. And then if, I threaten to disclose it,
Then it comes back
then it
into
would come
this.
in, then it would go to sextortion, the new bill. So then we appreciate, from our perspective is through these three different statutes, voyeurism, disclosure of explicit material, but explicit photo, sexual extortion, depending on those facts and circumstances, we can find, an avenue to pursue criminal culpability.
Thank you. I wanted to make sure that that was covered in underlying law. It does not appear here because it is. So I appreciate you sort of walking me through the three avenues.
And similarly with sexual extortion, and if anyone has the opportunity to listen to the House testimony, the parents who provided testimony about their children being involved in sexual extortion, it's a very powerful testimony. But in those cases, the images were shared knowingly with the consent by the juvenile that, thought it was okay. And then they were being threatened by it. So even if you consent to the images, if you're not, you're being threatened by those images and you're not wanting those to go out into the world, this would cover you. Happy to answer questions. I know there are a few questions around strict liability. I also know it's new, so I'm happy to come back on the questions about the immunity clause. There are a few things that have come up in your walkthrough.
Do you think that since we're at noon, maybe we should just adjourn for the day so that the conversations around those policies aren't too rushed?
Sure.
And then, we can have you back
Happy to come back.
at some point.
Very interesting
Yes.
conversation.
Thank you for the initial primer.
Great.
Perspective on it.
Thank you.
Thank you.
The unknown is wait for it. I hope that.
Yes. Noted. All right. We